A very good afternoon to all my dear students. Today we are going to discuss about the concept of appeal under the subject captioned as Code of Civil Procedure. My dear students, as you all are aware that after the judgment or the order, or as the case may be, decree has been passed in a civil suit against a party, then the aggrieved party may approach the higher courts, thereby to allege certain facts which have been ignored by the trial court. This system of re-examination of facts and law in respect of the civil suit decided by the trial court, by the higher court, is known as the procedure of appeals, meaning thereby any persons who feel aggrieved by any decree or order passed by a court may prefer an appeal in superior court if an appeal is provided against that decree or order, as the case may be. Further, there are certain relevant sections and orders which you have to, or which one has to keep in mind while studying the concepts of appeal as laid down under the Code of Civil Procedure. As far as the first appeal is concerned, the relevant sections are section 96 to 99A and order 41 CPC. Second appeal provisions are laid down under section 100 to 103, 107, 108 and order 42. Third is appeal from orders. Sections are 104 to 108 and order 43. Appeal by indigent person, order 44. And appeal to Supreme Court. The relevant sections are section 109 and 112, which has to be read with order 45 CPC. So these are the relevant provisions which one have to keep in mind while reading the concept of appeal under the Code of Civil Procedure. Further, as far as the definition of appeals is concerned, the word appeal has not been defined in the Code of Civil Procedure. As you all are aware that certain terms or expressions have already been defined under section 2 of the Code of Civil Procedure, such as the concept of judgment, decree or order, or decree holder, etc. and etc. But various law lexicons or the law dictionaries define the word appeal as it is the judicial examination of the decision by a higher court of the decision of the lower / inferior court. Further, this was also substantiated by the Supreme Court or by the Privy Council, as the case may be, in the case of Nagendra Nath Dey versus Suresh Chandra Dey, wherein, speaking for the Judicial Committee of Privy Council, Sir Dinshaw Mullah stated that there is no definition of appeal in the Code of Civil Procedure, but their lordship have no doubt that any application by a party to an appellate court asking to set aside or reverse a decision of a subordinate court is an appeal within the ordinary acceptation of the term appeal. Next. We would like to explain it to you about what are the essential ingredients of appeal. These are, number one, a decision, meaning thereby. It's a decision usually of a judgment of a court or an order of the administrative or quasi-judicial authority, meaning thereby. Such decision may be passed by the court or by a quasi-judicial authority as the case may be. If it is a case of an appeal under the civil procedure, of course, this appeal must be from a decision in a civil suit filed by the plaintiff. Second is a person aggrieved who is often, though not necessarily, a party to the original proceedings, meaning thereby a stranger can also file an appeal against the order even though he was not the party before the trial court, but subject to the terms and conditions, and it is subject to the condition that that person would fall within the definition of a person aggrieved. And the last one is a reviewing body ready and willing to entertain an appeal. So there must be a reviewing body, meaning thereby there must be a higher authority to review the order passed by the trial court or by the inferior court. Now, I just want to explain it to you, the right to appeal and its nature and scope. As far as the nature and the scope of the appeal is concerned, this is not a natural or an inherent right, but it is a creature of a statute, meaning thereby if the statute provides a remedy for filing an appeal, then only the aggrieved party may go for it. And if the statute does not provide such a remedy, then that order would tantamount to be the final order. And it may be challenged not by way of appeal, but by way of review or revision, as the case may be. Further, if it is a creature of a statute, meaning thereby, if the statute provides the remedy of filing an appeal, then it may be claimed as a matter of right. But if the statute does not provide this remedy, then it cannot be claimed as a right. But maybe it may depend upon the discretion, and sometimes the alternate remedies may also be invoked, such as review, revision, and reference, as the case may be. For example, as far as the discretion of the court is concerned, you have an exclusive example where an appeal can be filed at the discretion of the court, and the leading example on this is the filing of an SLP, that is special leave to appeal, to the Supreme Court under Article 136 of the Constitution of India. Further, as far as the right to appeal is concerned, it is also a substantive right, and it is not merely a matter of procedure. Further, it may be said about the concept or the expression of the appeal that this right is a vested right, meaning thereby if the statute provides this remedy, then in that case, this would be tantamount to as an vested right, meaning thereby it accrues to the litigant as and from the date the litigation commences, meaning thereby this right to be computed from the date of the filing of the case and not accrued on the date of the filing of the appeal. So if, meaning thereby, appeal is a continuation of a civil suit. Vested right can be taken away only by a subsequent enactment if it is so expressly or impliedly. This was so held in the case of Anant Mills Company Limited versus State of Gujarat, EIR 1975, Supreme Court 1234. Meaning thereby, this vested right can be taken if the statute take away this right either by way of express or implied enactment. Further, what is the why this right is to appeal has been given, or what is the object behind the right to appeal? It is based upon the saying that all men are fallible and judges are human beings and may commit mistake. So to rectify the mistake committed by the court of law and based on the legal maxim that the court's order cannot prejudice anyone. So that is the reason behind or the object behind the right to appeal. As far as the right to appeal with regard to first appeal are concerned, relevant provisions I had already applied it to you, and I am again quoting it for the sake of understanding that section 96, section 100, 104 and 109, these are the rights which not only talks about the first appeal but also about the second appeal and appeal from orders and also from the appeal to Supreme Court. What is the effect of no right to appeal? Right is neither a fundamental right nor an inherent right, but only a statutory right. If the statute does not confer a right to appeal, no appeal can be filed, and such law cannot be held to be unconstitutional or ultra vires. If the statute does not provide the right to appeal, what will be its effect? Meaning thereby, whether that order would be held unconstitutional or not, or whether that particular enactment would be unconstitutional or not. Answer is no. The such statute would remain valid, and this was so held in the case of Kartar Singh versus State of Punjab, 1994, 3 SCC 569. Now, I just want to explain it to you over here. What is the difference between suit and appeal? This was so explained by Justice Chandrachud in Gangabai versus Vijay Kumar, EIR 1974, Supreme Court 1126, wherein the Supreme Court says that the right to file a civil suit is inherent in every person to bring a civil suit of civil nature unless the same is expressly or impliedly barred. Meaning thereby, right to file civil suit or right to institute a civil suit is inherent, whereas it is not so in the case of filing of an appeal. Meaning thereby, an appeal for its maintainability must have the clear authority of law. Meaning thereby, The statute must provide this particular remedy. Appeal only reviews and corrects the proceedings in a cause already constituted, but it does not create the cause, whereas civil suit creates the cause of action in favor of the plaintiff, thereby, thereby to help the plaintiff to file or to institute a suit in a court of law. As far as the concept regarding the appeal is a continuation of suit, this was so held or approved by the Supreme Court in the case of Garikapati Viraiya versus N. Subbiya Chaudhary, EIR 1957, Supreme Court 540, meaning thereby a decree passed by an appellate court would be construed as decree passed by the court of first instance. The appellate court possesses the same powers and duties as the original court. Now I just want to conclude the points which are relevant for the understanding of this concept and which I had already apprised you in my previous slide. And these are: suit, appeal are really but a step in a series of proceedings all connected by an intrinsic unity and are to be regarded as one legal proceeding, meaning thereby appeal is a continuation of suit. Second, it is not a matter of procedure, but it is a substantive right, meaning thereby appeal is a substantive right. Third, institution of suit carries with it the implication of right to file the appeal, meaning thereby right to appeal depends upon the filing of the civil suit. Further, the right which had been there in the statute at that time, the relevant statute or the calculation of the time period would be started from the date of the institution of the suit and not from the date of the filing. Third, vested right accrues to the litigant on the date of the litigation commences. This right can be taken away by subsequent amendments. So this is all about today's lecture. In case of any doubt, my dear students, you may write it to me at my email ID, that is rahul.arora.gn@jagannath.org. Before parting with today's topic, I just want to apprise you with my new topic which I am going to take in my next lecture. And my next lecture would be on appeal from original decree. Thank you very much. Stay home, stay safe, and stay healthy. We'll meet you soon, all my dear students, in my next lecture very soon. Thank you very much again.